Good afternoon again to those of you on the East Coast, and good morning to those of you on the West Coast. Thank you for joining our webinar, Turning Your Negative Option Offer into a Positive, and it's brought to you by both me. I'm Ari Rothman, I'm a partner here at Venable, and my partner Shaheen Rothermel. We're both co-chairs of Venable's Autorenewal Solutions team, aka VAST, sorry, and we're happy to have you all here today. And here's our agenda, just a quick bullet points. We'll go through the federal and state laws, the requirements for automatic renewal programs, ways to reduce risk, and interspersed in there, we'll talk to you about the rule changes that are coming down the pike too. That's been a topic of discussion. And as always, there's a lot to cover in only an hour, and we could spend a day talking about all these issues. So we'll cover as much as we can, and then we'll go from there. And first, we'll talk about federal and state laws. And this is why we created VAST. It's been something that we've been doing for a long time, but it's sort of come to a head in the last couple of years. Here's the current landscape. There are continuing and aggressive law enforcement activities to protect consumers, including state attorney generals, the FTC, and the CFPB. The Federal Trade Commission has always been active under ROSCA. That's been going on for quite some time. But what we've noticed in the last few years is state attorney generals, particularly in California, have been pursuing these actions and enforcement proceedings with more vigor than they had in the years before that. So that's something that is out there. And class action lawsuits to enforce state laws are also developing with higher frequency in the last year or two, maybe three, than they had in the years before. So this is an area that is picking up steam in the courts and in regulatory bodies. There's new state laws that target specific areas of concern. We'll go through a couple of those as we proceed today. And there are allegations of violations of so-called generation deception laws, accompanying alleged automatic renewal law violations. So we'll see some of that as well. So you sort of see this, it's not just the federal laws or specific laws, but some general laws as well. Federal law would also include, let's go through those, the Restore Online Shoppers Confidence Act, that's the telemarketing sales rule, the Section 5 of the FTC Act that's pursued by the government, the EFTA, Electronic Funds Transfer Act, and Consumer Financial Protection Act. So we've got these 5 areas of law that govern automatic renewal programs, or at least touch upon them in one way or another. The violations generally involve injunctive relief, or excuse me, if you have a violation, it's subject to injunctive relief or monetary relief, depending on which statute is being invoked. And there's statutory penalties of up to $51,744 per violation. I think that has increased since the last time we gave our webinar on this topic. I don't know, adjusted for inflation or something. So it's a hefty fine that is coming out of the federal system. And then I'll turn it over to Shaheen now, because we'll talk about the proposed updates.
Thank you, Ari. Excuse me. The FTC recently proposed updates to the negative option rule. So we'll be talking throughout the presentation about what those updates are. It applies, the first thing is that it's going to expand the entities to which it applies. It's going to apply to automatic renewal programs, continuity programs, free-to-pay conversions, or fee-to-pay conversions, like a discount to pay conversion, and pre-notification negative option plans, like the magazine of the month that we saw back in the day. In other words, this is going to expand the current negative option rule to essentially any type of program or plan where a customer is going to be charged if they do not take affirmative action to cancel or stop the charges. This is not just going to be what we used to think of as negative options, which were like a free trial that converted to paid. So the proposed rule is going to heighten the disclosure requirements, including the clear and conspicuous standards and the elements that have to be disclosed. It's going to also heighten the consent requirements. It's going to use this language, unambiguously affirmative consent, and might arguably impose a checkbox or similar requirement in practice. It also mandates acceptable cancellation options, including the so-called one-click cancellation rule that would effectively prevent a lot of save and retention efforts. As I said, it would limit the ability of a company to attempt to save the consumer. And we do not know when this is going to take effect. The FTC is incredibly busy. They've been having informal hearings as well as the comment period. So we don't know when this is going to be effect. And we also don't know if after it's published, there's going to be litigation in the industry that's challenging the FTC's scope and provisions simply because it is so expansive. As Ari mentioned a bit ago, the FTC could seek monetary penalties for violation of the rule. We're now at 51,744 per violation. What's critical about the rule, too, is it actually creates an independent violation for general misrepresentations or omissions that are unrelated to the negative option offer itself. So we saw this in the MoviePass case a couple of years ago, and there was another ROSCA case where the FTC said that the failure to disclose an incentivized review or an incentivized endorsement in connection with an auto renewal program violated ROSCA because it didn't appropriately disclose terms. Talk a little bit about that, but it's pretty scary stuff, and it could even encompass business-to-business service providers. There are also a number of state laws that are cropping up. General laws have been passed in over 20 states, and I got to tell you that it's increasing. That number is increasing daily. And those laws will apply to offers made through all channels. So not just online or telephone, but everything, in-person, mail sign-up. So anything that's an auto renewal program, it's generally going to be governed by one of these state laws here as well. There are hyper-technical requirements that are highly litigated in California and New York. Ari and I are going to talk about some of the specific cases so you can see how technical these plaintiffs went when they're challenging companies' practices. And there's injunctive relief and monetary penalties like refunds and statutory penalties in certain states. So these are enforced by the class action plaintiffs as well as state attorneys general. We have a lot of these cases going on right now in front of state AGs, as well as California's Automatic Renewal Task Force, CART, out in California. So, they're keeping us incredibly busy. A summary of the requirements for negative option programs. You need to provide clear and conspicuous disclosures prior to enrolling somebody in a negative option program. Obtain the affirmative consent of the customer to the material terms of the offer. Send an order confirmation after you've enrolled somebody in a program. Provide renewal reminders if the program is a certain duration. Typically, if it's an annual renewal, then providing renewal reminders. Provide a simple cancellation mechanism so people can easily cancel and get out of the offer. And if there's material changes to the offer, please make sure that you're sending notification about the changes prior to those changes taking effect. And there's really technical disclosure requirements in that too. You'll see as we go forward. The disclosure requirements are quite onerous, and you can get sued if you miss or misstate a simple word. We'll give you examples of where it went right and where it went wrong throughout the presentation.
Of the 6 things that Shaheen just went through, clear and conspicuous disclosures, they're all important, all 6, but clear and conspicuous disclosures in the second one, affirmative consent, those 2, full compliance with those 2 will reduce risk profiles. I'm not saying don't comply with the rest. You have to comply with the rest, but these are the things that are going to cause detection: failure to disclose and failure to obtain affirmative consent. What to disclose: all material terms of the transaction before obtaining the consumer's billing information. And here's what needs to be included. We'll roll through these. That the subscription agreement will continue until the consumer cancels. You'd be surprised how many people miss this. You have to tell the consumer that the subscription, the continuity plan, whatever you call it, will continue until the consumer cancels. Have to say that. You have to provide a description of the cancellation policy that applies to the offer, including the deadline by which to cancel. And we'll get into the cancellation mechanisms later. The amount of the recurring charges, including that if the price changed after a trial, the amount that will be charged when the trial ends. Basically, how much is the consumer going to get charged now and later? the payment method that will be used for the charges. So we're going to charge your credit card, debit your debit card. Those would be the two primary methods. The length of the subscription term. It's normally weekly, monthly, or annually. But if it's something different, tell them what it is. And if there's any minimum purchase obligation in order to get those, enroll for the subscription, you have to say what those are. And any other material terms, such as an early termination fee. I mean, if you terminate the subscription halfway through, then you're still going to be charged, or things like that. Anything that would be important to the consumer's purchasing decision, and this is all before obtaining billing information. So then, how to disclose it? This is the golden rule: a clear and conspicuous manner before obtaining the consumer's billing information. And for subscriptions with an initial term of 1 year or more, disclosures must appear in boldface for Vermont. And this is a key sort of example of a deviation from state laws and how they're continuing to develop. This is a Vermont only rule. You can do it in all 50 states. It'll reduce your risk profile. But this is one example of a smaller state imposing a requirement that needs to be complied with. Now I think I'll turn it back over to Shaheen. We'll go through some examples of where it went right and where it went wrong, so you can see how this is playing out.
Definitely. And Ari's completely right about how you've got states that are imposing hyper-technical rules that they do get sued under. We've received demand letters in Vermont, as well as the North Carolina rule that says if the subscription is going to change, that needs to be disclosed at the outset in bold, at least 12 font type. And we'll talk about a case where that went wrong and somebody got sued. What's coming up next? If the FTC's proposed updated rule goes into effect, here are the additional requirements to meet the clear and conspicuous requirement for providing clear and conspicuous disclosures. The name of the game is that it needs to be unavoidable. Somebody going through and completing a purchase on your website or over the phone must not be able to miss that disclosure. It must be easily understandable by ordinary consumers. The ordinary consumer is not the people on this telephone call and the participants in this webinar who tend to be sophisticated, intelligent, well-educated people. The ordinary consumer is going to be somebody who does not read very well, who cannot necessarily understand legalese. When I'm thinking about the reasonable consumer, I think about my mother, who English is her second language. Making that disclosure through the same means as the initial communication. So if you're showing something on the television screen, visually, make sure you have a visual disclosure. If you're saying something over a radio or podcast ad, making sure that you're doing an audio disclosure that makes sense. What's interesting, though, is that the FTC's rule would heighten this requirement. So if you've got a visual and audible communication, like a TV ad, the disclosure must be presented simultaneously in both the visual and audio portions, even if the claim is only made in one means. So if I'm saying something about my auto renewal program pre-trial, then what the FTC says is that I need to provide the disclosure in both state. I have to state that disclosure as well as writing that disclosure as well. No hyperlinks. This has always been the FTC's position, but they're going to really make that clear in this updated rule if it goes into effect in its current form. It needs to be delivered at a volume, speed, and cadence sufficient for ordinary consumers to hear and understand it. So making sure you're speaking slowly, no auctioneer voice, as we sometimes say. If the claim represents it targets a specific audience, like children or the elderly, the definition of ordinary consumers is going to be members of that group. So if you think about children, they're not going to be as educated, they're not going to read as well. So if you're selling something to children, making sure that the claim is the representation and the disclosure is easily understandable by those folks. Where to disclose? The updated rule says that if the disclosures are directly related to the negative option feature, then the disclosure needs to be immediately adjacent to the means of recording customers' consent. So that's going to be immediately adjacent to something like a checkbox or radio button or similar method to obtain consent. If the disclosure is not directly related to the negative option feature, then that must appear before the consumer makes a decision to buy, and the FTC says before they add to shopping cart. I will tell you that certain state AGs are taking the position that even the negative option disclosures. The terms associated with the billing program need to be fully disclosed before somebody adds something to a shopping cart. So we're really seeing that the FTC wants to put this in its updated rule, but we're also seeing that the AGs are taking this position as well. And as always, your communications can't have any other information that interferes with, detracts from, contradicts, or otherwise undermines the ability of consumers to read, hear, see, or otherwise understand the disclosure.
So here's an example of where it went wrong. This is a real case. This is where a court denied a motion to dismiss under California's automatic renewal law. And what the court had a problem with here is the disclosures on the website were not clear and conspicuous because the message was printed in text that is smaller and lighter in color than all other information on the page, and it does not in any other way call attention to itself. That's a quote from the case. You can kind of see above the second red box, plans automatically renew, and you are committing to the length of your BarkBox plan. That length isn't, I guess what they're saying is what BarkBox would say is it's above. You get to choose what your subscription is above, but still this was not viewed as appropriate. I would also say to this, as a piece of practical advice is we normally would recommend at some point in the flow, including right here and in multiple places, obtaining the consumer's agreement to terms and conditions that have a privacy policy and terms and conditions with a arbitration provision and class action waiver. It can't hurt to do it here and in other places. We go to the next slide. Here is a technical violations matter. This is coming out of North Carolina. We tried to do the best we could in terms of blowing it up, but the language that under the payment information was not presented in bold as required by North Carolina law. And the law there says if the terms of the contract will change upon the automatic renewal of the contract, disclose the changing terms of the contract clearly and conspicuously on the notification in at least 12-point type and in bold print. Again, another specific requirement. I guess if there was good news on this is that the judge found that the subscription checkout page, and we have a quote there from the case, can fairly be characterized as free of visual clutter and containing limiting text. So that's helpful. No dark patterns, nothing to like draw the user's attention away from the disclosures according to this decision. And the page does include a short 4-sentence paragraph above the purchase subscription button on the right side. But this is an example of, I don't know. I mean, arguably, if you didn't have this North Carolina law, we would argue this is defensible. But I mean, the legislature said you have to do it this way. And so the defendant's kind of in a bind, and so is the judge.
Yeah, I completely agree. And one thing that was interesting about this case, too, is that I think this was New York Times. What they had argued was that this requirement that the notification be provided in at least 12-point type does not make sense on the internet when you're viewing things on a web page. But a web developer doesn't type in 12-point font. You've got things like pixel size, you've got different screens, you've got screens that adjust. And the court acknowledged that issue, and it said, we're not going to deal with that today because the language isn't in bold. So stay tuned on if this continues to be litigated, if we get more guidance from courts on that issue. So here's the next case. I'm going to show you, this is a case involving Talkspace, and this is the user sign-up flow. So somebody would look at this and they would pick which one they want, and it says the price per week, and it says your price here, and it explains what you get. You select the plan, and then you review your plan on this page. Gives you a savings. It says live therapy monthly, 4 live seasons per month, 45 minutes. So got some language here about monthly. And then here's the payment details, and you put your information in, and then it says by providing your card information, you allow Talkspace to charge your card for future payments in accordance with their terms. Okay, so what's the problem? This went wrong. The plaintiff alleged that neither the checkout page nor any of the previous web pages said anything about automatically renewing charges. Don't know that I agree with that, since we just talked about how it had monthly there. It also says that the company failed to adequately disclose its renewal scheme, I put that in air quotes, or purposely misrepresents it in at least these ways. It says that the prices were shown and calculated in weekly increments, even though the term of the auto renewal is monthly. The FTC has taken issue with this as a dark pattern. It says if you're going to charge somebody on a specific frequency, you need to present the price of what it's going to be on that frequency. They call this a dark pattern. It's, quote, price comparison prevention. The plaintiff also alleged that the company failed to specifically describe the plan as an automatically renewing subscription plan. It's what Ari said earlier. You've got to actually be super explicit in telling people, hey, we're going to charge you on an automatically renewing basis. Plaintiff also said that the company failed to present the terms in contrasting text of a distinct size or color, and the checkout page on which consumers enter their credit card and authorize the company to charge the card fails to mention or reference anything about a subscription or automatically monthly renewal program. If you look back at the page before, it does say that you allow you're authorizing the company to charge you in accordance with the terms, but the plaintiff is saying that that's not explicit enough. You can see here, vague mention of future payments, but that language was also in a lighter color and smaller font than the rest of the text on the page. And the other piece that was missing was that no cancellation policy is identified. We see this a lot as one of the missing elements that's highly litigated, is that you get all of the other technical requirements that need to be disclosed that Ari was talking about, but then you don't specifically disclose the cancellation policy, or you omit something from the cancellation policy, like the deadline to cancel. Here's an example of where it went right. In this case, the court granted a motion to dismiss claims under the Oregon ARL. If you look on the page, you can see how it has bold language here when billing starts, and the fact that at the end of the free trial, the customer's subscription will renew automatically every month. Payments won't be refunded for partial billing periods. Cancel anytime through your settings. And then you've got the language saying by clicking start 1 month trial, you're verifying that you're at least 18, you're buying a paid membership and agreeing to the hyperlinked terms. Now, the plaintiff went after this company for a hyper-technical issue. You see that language saying payments won't be refunded for partial billing periods. The plaintiff said that there was also this wonky refund policy where you wouldn't be refunded unless you canceled within a certain window, which was 7 days. And it said, this doesn't explain that. And the court said, no. The requirement to disclose a description of a cancellation policy doesn't mean you have to disclose the complete policy, like the refund policy here. And you can contrast this holding. This is a very good holding for industry, but you can contrast that holding to what the court said what the FTC wants us to do with its updated negative option rule. The FTC is saying that this would be something that's material, so it needs to be disclosed. But the court here is saying, no, it doesn't, not under the current Oregon auto renewal law. Court also said that the text satisfied the requirement that the language be presented, quote, clearly and conspicuously, because it used contrasting type as a surrounding text. The key offer terms are featured in bold font, you can see that there, and then the gray line divided the page to further demarcate the terms. It's that gray line that appears below monthly charge. I think one of the things about this case, it goes to show you, is that a good way, probably lower risk way to disclose is using bold font. Here's an example of where it went right. In this case, the court found the disclosure to be sufficient. You've got, again, that bold font there that says your subscription will automatically renew every 12 months unless you terminate your contract at least 28 days before the end of the initial term or any renewal term. And then you've got a checkbox there on the payment page as well, where the person would agree to the end user license agreement and the term. So the district court, federal district court, said that this was sufficient because you have this in bold and you've got this language here. And the Ninth Circuit actually affirmed. The Ninth Circuit said that they were put on notice of the auto renewal terms, the fact of the subscription, the price upon renewal, the cancellation policy, and the process. So you've got that helpful case that's good for industry on that one as well. Ari, do you want to talk about affirmative, express, informed consent?
And before we get into sort of the moral of the story with some of these cases that went wrong, is that although doing clear, conspicuous disclosures, and as we're about to go through, affirmative and express informed consent will reduce your risk profile in the sense of someone, exposing yourself as low-hanging fruit. It only takes one violation as you'll see, to get yourself tied up in one of these class actions, less likely a state AG investigation. It would depend on how severe the violation is, but the class action lawyers are all over it. Just missing one thing and literally turning it into a federal case. Affirmative and express informed consent. This is also very important. Must obtain the customer's affirmative, express informed consent before obtaining the consumer's payment card information, whether it's a credit card, debit card, bank account, PayPal, Venmo. There's all these other cash apps. Any type of payment information this rule applies to must be affirmative and explicit agreement of the consumer to enroll. We have to be able to show, and you have to be able to show, that consumers consented to the specific auto renewal program, not that they considered or consented to purchase something generally from the site or something with the auto renewal, like this program. We have to be able to point to something. Silence or ambiguous response is not equal to consent. So, for example, if it's added to a cart automatically, the consumer didn't add it there, and then the consumer goes all the way through the flow, that may not be enough to establish consent. The informed consent piece is having been appropriately informed of the offer disclosure as a consumer provides consent. So it's sort of like, it's not just any consent. The consumer has to know what they're consenting to. So what is affirmative consent? It's an affirmative action opting into or consenting to or agreeing to the automatic renewal provision. Some regulators, even if the state statute doesn't require it, have been pushing for a checkbox signature or similar method, which the consumer must affirmatively select to accept the negative option terms and no other portion of the offer. So just be aware that's something that might not be legislatively required, but it is something that the regulators are pushing for when you want to settle with them. Vermont law, you have, again, deviation and special rule that if the term is 1 year or longer and the renewal term is 30 days or longer, must agree to auto renewal separately. The consent mechanism should be in visual proximity to the request for consent, above, below, next to, preferably the disclosures are right above, and then there's a consent mechanism right next to it, either an unchecked checkbox or some other call to action. And the consent, the disclosures and checkboxes should not be muddled with other disclosures. So don't bury the auto renewal terms with any other, offers, advertisements, other consents. Make it stand out, and create at least a paragraph separation. Use headers to distinguish the text. It really sort of has to. Glow in the dark is a little bit extreme, but pretty close to that. That would be the gold standard. Additional consent for program-specific offers for a free trial of a good or service with a term of 1 month or more, where the contract renews at the end of the free trial period. The seller must notify the consumer of the automatic renewal between 1 and 7 days before the free trial period ends, and notwithstanding the consumer's consent to the free trial, obtain the consumer's affirmative consent to the automatic renewal before charging the consumer for the automatic renewal. This consent must be obtained even if the consumer has already provided affirmative consent to the free trial. So if you're doing free trials, you sort of have to go through this extra step that's identified here. Now we're on to, I don't know, Shannon, maybe you want to do these changes?
Sure. The proposed rules, updates to the negative option rule, would create additional obligations for obtaining consent. So what the FTC says is that the seller must separately obtain unambiguously affirmative consent, both for the negative option term and also for the rest of the transaction. And the proposed rule says that the negative option disclosures must appear immediately adjacent to the request for the consumer's consent for the negative option feature. As already pointed out, best option is going to be an empty checkbox, and you can see that here, which is that the proposed rule says that a seller will be deemed in compliance with the requirements if that seller obtains consent through a checkbox, signature, or other substantially similar method that somebody needs to affirmatively select or sign to accept the negative option feature and no other portion of the transaction. We've gotten 2 questions on the consent side that I'd like to address before we go too much further. One of them says, what if we've already got the payment method on file? And we're talking about how you have to get this consent and provide the disclosures prior to obtaining the payment information. So as a technical matter, the best practice would be to provide the disclosures and obtain consent before you charge somebody and before you get credit card information. For example, even in the upsell, we often see these one-click upsells or things like that. That's going to be something that a regulator is typically going to frown upon unless you're regaining consent. We've seen hybrid models where companies will re-provide the disclosures and then simply say, I agree to have my card on file ending 4 digits for the auto renewal. So something like that would be the way that it could be presented as well. Somebody also asked if all we do is offer automatic renewals and we don't offer anything else, why do we still need additional consent? I think that the FTC and the FTC and state regulators would say yes. We saw that a lot in the trial space when we were defending those. I know ROU defended dozens of those over the past couple of decades, even before ROSCA went into effect. So I would say that, the FTC has only become more stringent in its requirements in that regard. When we use the word negative option, just to be clear, that does include memberships with automatic payment. So the word negative option we are using very, very broadly in this presentation. Okay, the age-old question, is a checkbox required? Regulators say yes. California's Auto Renewal Task Force, or CART, says that in all of its settlements, says that companies need to obtain consent through an express act, like a checkbox signature, express consent button, or a substantively similar mechanism. And that mechanism can't relate to consent for anything other than the offer terms, which is final payment. Needs to be immediately adjacent to the consent mechanism, like Ari talked about earlier. Most recently, we saw that in a case that was announced in January against the flower company, that sold flowers on automatic renewal, let you sign up if you want, for example, to do monthly flowers. I suppose that's one way to stay in the good graces of a significant other, is have auto renewal flowers on auto renewals. The FTC's enforcement statement, as well as its proposed negative option updates to the negative option rule, also say that a checkbox is going to be required, or some other substantively similar mechanism is going to be required. And one thing that it also says is that a pre-checked box does not constitute affirmative consent, and that you can't assume consent. As Ari said, silence is not going to be assumed to be consent. Before I go on to the next slide, I want to provide the CLE code. The CLE code is VAST 2024. That's VAST 2024, VAST as in Venable's Auto Renewal Solutions team. Is a checkbox required? These courts say no. I am ecstatic to report that the case law is just really coming out in favor of industry on this checkbox requirement. So we've seen courts interpret Oregon's auto renewal law and even California's auto renewal law and say that a checkbox is not required. In the Walking Eagle case, Google versus Walking Eagle, it was issued last year out of Oregon. Oregon's automatic renewal law mirrors California's auto renewal law with respect to disclosures and consent requirements. There's some other stuff we'll talk about later. But the court looked at that auto renewal law and said a checkbox isn't required as long as customers have the necessary information to make an informed decision to commence the free trial in the auto renewal program. And in that page that was involving YouTube, when you read the page from top to bottom, customers were forced to encounter the auto renewal offer terms. It was unavoidable. Then there was a description of additional terms, and then the confirmation button, and said, you know what, people are informed. They clicked the CTA. They were told that by clicking that CTA, they were giving consent. That is enough. In Audible versus Averas that came out of Washington, the court said California's auto renewal law requires conspicuously disclosing renewal policies in plain language, of course. It does not, however, require a separate checkbox indicating consent to the auto renewal term. And this is what's really cool, is that the plaintiffs in the Averas versus Audible case, in this case, cited to a bunch of California task force cases to say that, look, the California Auto Renewal Task Force requires a checkbox, and therefore, court, judge, you should too. The court said, hey, I hear your argument, but those are not the law. None of those orders cite or purport to interpret California's ARL. So really, really great news. Another case that came out just last month, and this should say 2024, not 2023, rejected the argument that the defendant violated the California ARL because the defendants did not at any point during the checkout process require consumers to read or affirmatively agree to any terms of service associated with their subscriptions, for example, by requiring customers to select or click a checkbox. Court says, no, that is not required for California's automatic renewal law. So again, we're getting some really, really good case law there. Let's talk about order acknowledgments as well. And one thing before I go much further, and Ari and I, as I mentioned, are defending a ton of these cases. And as you can see here, the case law is really just mounting up. And one thing that we've been using this to defend clients, and what we've been doing with regulators and class action plaintiffs is essentially telling them that time isn't on their side, because the case law is just really overwhelmingly saying that checkboxes aren't required. Having said that, we can see the move on the regulator side towards a checkbox. So best practice is always to get a checkbox, because we also can't guarantee that courts won't come out the same way and say, other courts will say, hey, yeah, a checkbox is required. Order confirmation and acknowledgement is becoming an increasingly hot area for class action plaintiffs attorneys, because it does have specific requirements, technical disclosure requirements. State laws generally say that companies must send an order acknowledgement, quote, in a manner that is capable of being retained by the consumer with material terms of the offer. That means you can't have a pop-up, you can't have a similar screen. It needs to be something that somebody can revert back to if they want to know what they signed up for. You need to include in that the terms of the automatic renewal program. Those need to be clearly and conspicuously disclosed. The cancellation policy, including information about how to cancel and a hyperlink to cancel. And if the offer is a free gift or trial, make sure you disclose how to cancel before the customer will begin paying. I wanted to call out two of these gotchas that were called out by cases. So one of them is the case that came out involving Amazon. Its order confirmation had language like modify and change. The court rejected this, said this is not enough. The language said review your subscription by visiting settings, or to learn more, make changes, manage your membership. Didn't have it, and the court said you missed that technical requirement, so the court refused to dismiss claims. Another court, in a case involving Weight Watchers, said that acknowledgement was insufficient when it said instructions on how to cancel are located in the help section of the site, because it didn't have a hyperlink and it simply directed people to the help page. So be very careful when you're doing those types of, you're doing your order acknowledgement. And again, read it with a checklist for all the requirements, because as Ari said earlier, you miss one of these and you're going to have to find yourself defending a lawsuit.
That's a good segue into simple cancellation mechanisms. The mechanism has to be simple. It cannot require a lot of steps. It can't be confusing. It can't take a lot of time. That's sort of like the concise way of summarizing what can happen. What must happen, according to the various state laws, is you have to provide, in federal, by the way, a simple, cost-effective, easy-to-use, and readily accessible mechanism for a consumer to stop the recurring charges. Providing a toll-free number, email address, postal address, or other cost-effective, timely way, and easy-to-use mechanism that a consumer can use to cancel. Having provided those methods, there are a lot of states, including California, that require the cancellation method to be online if the offer was online. So you can't, for example, require someone to call you if that user signed up online, or mail in or do anything other than cancel online. It's an absolute requirement. and it just has to be done in these states that are listed here in the third bullet. California has some very specific cancellation requirements in addition to the one that was on the last bullet on the previous slide. If a consumer accepts the offer online, provides that affirmative consent we were talking about, the consumer must be allowed to terminate exclusively online at will and without engaging in any further steps that obstruct or delay the consumer's ability to terminate immediately. One click to cancel, for example. That is essentially what California is saying needs to happen to allow consumers to stop the charges. So, being more specific about it, the business must provide a method of termination online, either in a prominently located direct link or button, which you can put it in the customer account or profile section, or within the device or user settings, or by an immediately accessible termination email formatted and provided by the business that a consumer can send without additional information. Now, the business can require consumers or customers to enter account information or otherwise authenticate their identity before actioning the termination. That's to prevent fraud and other things. But a consumer who is unwilling or unable to enter account information or otherwise authenticate themselves before termination can't be precluded from authenticating or terminating using another method. So if there's either a technical glitch or they can't provide that information, then they still need to be permitted to terminate in other ways. As a practical matter, when we're talking about cancellation, the people that are there's two groups of people that are most likely to complain, putting aside the regulators that go out and just surf the internet to find something. The first group of people are the ones who are going to say, I did not know that I was going to get charged for this or that I even purchased it. That gets back to the clear and conspicuous disclosure requirements and the affirmative consent. That's how you solve that group of customers. The second group of customers, they might still say, I didn't know I signed up or whatever, but if they can't cancel and they're still getting charged, they're going to make that complaint. And so if you have a user or a customer who does not want to be charged, I would say that you're incentivized to comply with this requirement even outside of California, because those are the people that are most likely to cause you problems. This doesn't apply outside of California, although some AGs might say it does, maybe even the FTC. But this is not a bad practice to lower risk. I understand it's not as business friendly as other states, though. Going on to the next slide. Here is the FTC's position. The cancellation must be, quote, at least as easy to use, i.e. the same method, as the method the consumer used to initiate the negative option feature. So it's kind of the same thing as what happened in California. The cancellation procedures must be effective and must be honored promptly. Do not thwart or hinder consumers' cancellation efforts, and avoid subjecting consumers to additional sales or save offers if such offers impose an unreasonable delay on consumers' cancellation efforts. Very similar to California, not as specific, but if you comply with California, I don't know, what do you think, Sheen? I think you're in good shape with the FTC.
I would say so. I think the FTC's proposed changes to the negative option rule might be a little bit more onerous if you want to talk about those.
So this is the one-click cancellation and mirror cancellation rule that isn't there yet, but might be. This does require the one-click cancellation mechanism that mirrors the customer's enrollment method. So this would be similar, if enacted, to the California piece at the top of that slide, 2 slides ago. The cancellation must be at least as easy as the enrollment mechanism, be provided through the same medium that the consumer used to enroll, and after receiving the cancellation request, the seller must immediately cancel, unless the seller obtains the consumer's unambiguous affirmative consent to to receive a save prior to cancellation. And such consent must apply only to the cancellation attempt in question and not to subsequent attempts. So if this is passed, then it's kind of like California and the FTC are going to trump and apply to all 50 states, because you can't practice in one law or one state and not be subject to the FTC's proposed rule if it in fact goes into effect. Save attempts. So what is a save? Well, everybody knows what a save is, but the rule actually defines a save as an attempt by a seller to present additional offers, modification to the existing agreement, reasons to retain the existing offer, or similar information when a consumer attempts to cancel. We've given some additional bullets here, and I think we're running a little short on time, so I'm not going to go through all of them so we get to other issues. But check out the last bullet, which I think is important. Hangups and disconnects must be presumed to be cancellations. So basically, if they call in and you don't complete the cancellation attempt, it's considered a complete cancellation. That's sort of key to this, and we'll have the slides available so you can pick up on the rest of it. I think we have, moving on to the next topic, on slide 37, we'll talk about some more class actions. Shaheen, do you want to take this one?
Sure. So class action plaintiffs have filed lawsuits that challenge similar practices that the FTC is, including things that already said, like continuing to charge people after they attempted to cancel, failing to disclose that somebody has to cancel a certain period in advance of the next renewal for cancellation to be effective, chatbots' inability to process plain language requests for cancellation. This is a big line. If you have customer service reps, or even, or if you're programming your chatbot or you have customer service reps, be very careful in what you're telling them must be dispositioned or treated as a cancellation request. I can't tell you how many times I've seen companies get sued, or how many times we've had to defend an investigation and the FTC says, you have customer service reps out there who are not being told that, somebody trying to cancel, unless they explicitly say, yes, I want to cancel, or use magic words, you're not treating those as a cancellation. So being very careful about that. The word that we hear a lot is friction, adopting complex procedures to increase the friction in the subscription cancellation process. You don't want to have your subscription program where there's absolutely no friction in the sign-up program and there's a ton of friction in the cancellation program. Like, that's not something that you want to have a class action plaintiff alleging, or the FTC or state AG alleging, because regardless of whether you comply with the language of the law, and that's not what we're talking about right now, optically it's very difficult to defend. And so providing a simple, well-disclosed, effective cancellation mechanism can help defend claims. So here was a case that was brought against Cerebral. What happened in that case was plaintiffs alleged that the company made it really difficult for them to cancel their subscription. The problem, though, was that for there to be a private right of action, the plaintiff had to actually try to use the cancellation mechanism that was disclosed. And in that case, the plaintiff did not try to use the cancellation mechanism that was disclosed, and therefore the court said, hey, you don't have standing to sue under the statute based on this allegation, because you weren't harmed by the fact that you tried to cancel. And unfortunately, for Cerebral, they also recently had a settlement with the New York Attorney General, who is currently doing a sweep of these companies of subscription programs. And in that case, the AG alleged that Cerebral created a long and burdensome cancellation process, continuing to charge people after they tried to cancel. What happened was somebody would submit a cancellation request on a chat box, and then Cerebral would then email the customer saying, hey, you sure you want to cancel? And then the customer had to affirmatively respond saying, yeah, I want to cancel. And what would happen is a lot of people got auto-renewed in that interim time because they thought, hey, I've asked to cancel, they're going to cancel me, right? That didn't happen, unfortunately. And the settlement requires Cerebral to establish a click-to-cancel process and refrain from making save attempts. So we're really seeing regulators' distaste for save attempts here. I'm going to go quickly over renewal reminders. I also would like to acknowledge we've got a lot of content here, so I'm going to go relatively quickly over this. And if there's one of these areas that you'd like us to do a deeper dive as just one standalone webinar in, please let me know, because we really want to give you guys good content, but we also want to make sure we're fulsome in all the requirements. And given the technical requirements, it's very difficult to cover everything fully, completely in 1 hour. So again, if you have any feedback on what we could talk about in a full webinar on one of these issues, please let me know. So some states require renewal reminders. The name of the game on this one is that if you have a term, if you have like an annual program that renews annually, definitely send a renewal reminder. The general rule, though, is that if the initial term is 12 months or more and then it automatically renews for a term of 1 month or more, you got to send it a renewal reminder. And North Dakota prohibits auto renewal periods that are greater than 1 month. So just be mindful of that. It's a small state, but mighty in its auto renewal law. Renewal reminders vary depending on the state. So we've got some states that say 15 to 30, others that say 30 to 60. We've got one that's 25 to 40. We have 15 to 30. So it's just being mindful of those timing requirements, because if you don't meet the timing requirement and someone says that they didn't get the renewal reminder in time, or they didn't get it in the appropriate time period, therefore they couldn't cancel before they got renewed, then you can find yourself in trouble. California requirement for notices, if you've got a free gift or trial that lasts for more than 31 days, then you have to provide that renewal reminder 21 days before the expiration. And you have to provide specifically disclosures. Here's California's requirement for an annual renewal. So if you got an annual subscription term, give that disclosure, that notice at least 15 days, not more than 45 days before. If you have material changes to your offer, you also need to provide a notice of those material changes with the clear and conspicuous disclosure about that change. Provide that best practice in a manner of being capable of being retained, and really alert somebody that if they don't want to be locked into the change that they can cancel, give them a method to cancel. You don't want to find yourself in a situation where somebody, you tell them about the change, but then they can't cancel. You should really assume that price changes are material, and any type of significant change to what the consumer is receiving is material. We're seeing a lawsuit right now involving one of the streaming platforms, I believe it's Amazon Prime, where they locked somebody into a $6.99 a month rate for ad-free streaming content. And then now they've changed it so that they are providing ads for that $6.99 price point. You got to pay more if you don't want to have ads. And the plaintiffs are challenging that. That price change is a material change. Best practices to obtain affirmative consent to changes. If it's a big change, then we really do recommend obtaining that consent. Here's some state-specific requirements that we'll leave as take behinds in these slides. I won't go behind them. I think we've talked about each of these independently. Ori, do you want to talk about how you can reduce your risk and prepare a defense? What puts you, Ari, in the best position when you have to defend a class action in California on one of these?
I try to go through, intersperse some of that because I knew we'd run low on time at the beginning, but review and update your consumer-facing messaging, all mediums of it, and maybe do it a couple times a year. Audit the customer service policies and procedures. We want to, well, let me back up a second. I mean, we want to be able, going back to the first set of slides, to be able to show clear and conspicuous disclosures and affirmative consent. We want to be able to do that. We want to be able to show compliance with all of the other requirements as well. But when we're talking about reviewing and updating and auditing, that also, it's not explicitly stated here on the slides, but that is to make sure that you are up to date on best practices, changes in the actual statutes and regulations, and the case law, because it changes, it's developing. And if you just do it once now and sit on it for a couple of years and don't do anything, you're probably going to you might be either doing something you don't need to do anymore, or you might need to be doing more than what you are doing. Audit your cancellation policy. The easier it is for the consumer, the better. Again, these are the people that don't want to be charged, and if you keep charging them, they're the ones that are going to scream, and they're the ones that the FTC and the state attorney generals are going to listen to when they open an investigation. Adopt a generous refund policy. Same thing. I mean, if they complain, I mean, my rule's always been, whether it's auto renewal or something else, give them assuming it's not materially impactful to the business, give them their money back, because again, those are the ones that are likely to cause you problems. Monitor and address complaints. BBBs, it's not like the end all say all, but you can sort of detect some issues if you see a spike in BBB comments during a defined period of time, and other websites like the BBB, and look at your metrics. If you collect cancellation reasons why people are canceling, they're going to tell you. I mean, they're like they're like your doctors. They're going to be able to tell you, what the issues might be that need to be addressed. Um, Ways to prepare defense, assuming that you're compliant, retain the offer funnels that the customer has viewed so that we can use those to diffuse any argument that clear and conspicuous disclosures were not made or they didn't give affirmative consent or whatever it is. Document, this is a cousin of that, document retain evidence that customers agreed to your terms and conditions, including any mandatory arbitration and class action waivers. You're going to want to use that as a line of response when you get a demand, assuming that everything lines up. Retain documentation of your compliance. Sometimes things don't go as they are documented, but if you can show that whoever's complaining had an experience that was atypical of everyone else, even if that consumer encountered some technical violations, but nobody else did, then that will diffuse class action risk as well. And evaluate the complainant's experience. I mean, I always try and recreate the experience from the consumer anytime a consumer has an issue to see what happened and see if anything went wrong. Sometimes nothing went wrong. Sometimes it was a complete disaster and anything in between. But we want to be able to do that so we can say what happened. Otherwise, it's going to be our word against theirs. And juries and judges tend to defer to plaintiffs more than they defer to the big corporate defendants. And that's just the reality of it. But here's some questions that you would want to ask as you are evaluating any given specific consumer's experience. And then analyze defenses to a class action. We could do a whole webinar on that, on the differences between complying and the issues associated with complying with the automatic renewal laws and the other laws that govern subscriptions, and then the technical requirements to get a class certified. They overlap, but they are not the same. And again, this is something I've said a couple times. Make sure you got a arbitration provision and class action waiver in your terms, and make sure it's enforceable. So, for example, make sure it covers the actual dispute, and you're not making them to fly. You're not making them fly across the country over a $10 dispute. I mean, make it very consumer friendly. Obtain consent to the hyperlink terms and conditions. Checkbox and scroll through are the lowest risk, but you can also have it around the call to action. Those have been increasingly, in my opinion, based on what I've been doing and seeing, enforceable. Make the notice of the terms and conditions unavoidable, have the font be sufficiently large. You can require, look, if you can get them to require to consumers to agree to a checkbox, great, but again, not required. Blue underlined hyperlinks. Why do we say blue underlined hyperlinks? Because there's a case in the Ninth Circuit that people have been citing to where the court said that would be sufficient. But it doesn't have to be blue. Just make sure it stands out and label the hyperlinks consistently. Terms of service versus terms and conditions. Don't confuse the consumer. And there's no reason not to be consistent, really. And make sure they're enforceable. I think I hit that up at the beginning. It is now at the top of the hour. And I know we have a lot of questions that have gone unanswered, and that's just the nature of us trying to pack in as much information as we can. You have our email addresses and phone numbers here. Feel free to reach out. Again, apologies that we didn't get to what feels like 98% of the questions that scrolled across our screens, but we hope you found this helpful. And this is an exciting area of law for us. We love doing this and watching the developments. And there's not a day that's gone by, and I can't tell you how long where we haven't spent a significant amount of time each day dealing with these issues. So thank you for attending, and have a great weekend.
Thank you all.